Good day, everyone. Are you ready to test your knowledge on political law in the legislative branch? Join us as we dive into the world of political law and explore the inner workings of the legislative branch. This Q&A format video is perfect for bar candidates looking to brush up on their political law knowledge and gain a deeper understanding of the legislative process. So grab your notes and let's get started on this exciting journey towards passing the bar examination with flying colors. Disclaimer: this video is not intended as legal advice. This video is produced for entertainment purposes only. Viewers should not rely upon the information presented in this video as legal advice. Although the video is accurate to the best of our knowledge as to the date of its production, the law changes constantly and viewers should consult an attorney for specific legal advice. It is important to note that this video is not a substitute for actual bar exam review. While the video provides an overview of the topics covered in the bar exam, it cannot replace the comprehensive review and study that is required to succeed in the exam. This video should be used as a supplementary to your preparation for the bar exam and not as a replacement for it. Let's begin. What is legislative power? It is the authority to make laws and to alter and repeal them. What is the meaning of the plenary character of legislative power? Congress may legislate on any subject matter. What are the substantive limitations on legislative power expressly stated in the Constitution? First, no law shall be passed abridging the freedom of speech, of expression, among others. Second, no law shall be made respecting an establishment of religion or prohibiting the free exercise thereof. Third, no law impairing the obligations of contract shall be passed. Fourth, no ex post facto law or bill of attainder shall be enacted. Fifth, other departments or agencies. Sixth, prohibition against the use of public money or property for a religious purpose. Seventh, no specific funds shall be appropriated or paid for use or benefit of any religion, sect, except for priests assigned to the AFP or penal institutions. 8. No law granting any tax exemption shall be passed without the concurrence of the majority of all members of Congress. 9th. All money collected on any tax levied for a special purpose shall be treated as a special fund and paid out for such purpose only. 10th. All revenues and assets of non-stock, non-profit educational institutions. 11. No law shall be passed increasing the appellate jurisdiction of the Supreme Court as provided in the Constitution without its advice and concurrence. Last, no law granting title of royalty or nobility shall be passed. What are the substantive limitations of legislative power impliedly stated in the Constitution? The prohibition against irrepealable laws and non-delegation of powers. What are the procedural limitations on legislative power stated in the Constitution? These are limitations on the manner of passing laws. There must only be one subject to be stated in the title of the bill to prevent hodgepodge or log-rolling legislation. Second, 3 readings on separate days, printed copies of the final bill in its final form to be distributed to members 3 days before its passage, except if the President certifies to its immediate enactment to meet a public calamity or emergency. Upon its last reading, no amendment is allowed and the vote thereof taken immediately and the yeas and nays entered into the journal. Third, appropriation, revenue, tariff, bills authorizing the increase of public debts, bills of local application, and private bills shall originate exclusively in the House of Representatives. What is law execution? It is the power to adopt implementing rules and regulation What is lawmaking? It is the power to make laws and to alter and repeal them. What is supplementary rule making? It applies when an agency of the executive branch or the concerned administrative agency executes a law by creating, implementing rules and regulations. Here, what is left for the agency when it formulates rules and regulations, implementing the law is to fill up the details, based on the case of Abacata Gura versus Purissima, subject to the test of completeness and sufficient standards. What is contingent rule making? It applies when an agency of the executive branch or the concerned administrative agency executes a law by creating, implementing rules and regulations. Here, what is left for the agency when it formulates rules and regulation implementing the law is to ascertain the facts necessary to bring the law into actual operation. Based on the case of Abacadaguro versus Purissima. What are the exceptions to non-delegability of legislative power? First, subordinate legislation made by administrative agencies. Second, delegated legislative power to local governments. Third, legislative power reserved to the people by the provision on initiative and referendum. Fourth, emergency power delegated to the executive during a state of war or national emergency. Fifth, certain taxing powers of the president. What is people's initiative? It is the power of the people to propose amendments to the Constitution or to propose and enact legislation through an election called for the purpose. It is the power of the people to propose bills and laws and to enact or reject them at the polls, independent of the Legislative Assembly. It is entirely the work of the electorate. It is a process of lawmaking by the people themselves without the participation and against the wishes of their elected representatives. What are the three systems of initiative? Initiative on the Constitution, initiative on statutes, initiative on local legislation. What is a referendum? It is the right reserved to the people to adopt or reject any act or measure which has been passed by a legislative body and which in most cases would, without action on the part of the electors, become a law. It is begun and consented to by the lawmaking body. It consists merely of the electorate approving or rejecting what has been drawn up or enacted by a legislative body. What are the requirements for a petition for a referendum? First, a petition should be registered with the Commission on Elections. Second, it should be signed by at least 10% of the total number of registered voters. Third, every legislative district must be represented by at least 3% of the registered voters thereof. A bicameral Congress comprises of two chambers of Congress. True or false? True. The Senate and the House of Representatives. What is the composition of the Senate? The Senate shall be composed of 24 senators who shall be elected at large by the qualified voters of the Philippines as may be provided by law. What are the qualifications of a senator? First, a natural-born citizen of the Philippines. Second, on the day of the election is at least 35 years of age, able to read and write, a registered voter, a resident of the Philippines for not less than 2 years immediately preceding the day of the election. The qualifications of the senators must be possessed before the day of the election. True or false? False. The qualifications of the senators must be possessed during the officer's entire incumbency. The qualifications of both senators and congressmen prescribed by the Constitution are not exclusive and subject to additional qualifications by Congress. True or false? False. The qualifications of both senators and congressmen prescribed by the Constitution are exclusive, and the legislature may not make additional qualifications. May a member of a religious cult be disqualified for running for Senate or Congress? No. Property qualifications are not allowed, as no person may be denied a chance to be elected to public office by reason of poverty. What is the term of office for senators? 6 years to commence at noon of June 30 following the election. A senator may serve for more than 3 consecutive terms. True or false? False. No senator shall serve for more than 2 consecutive terms. Voluntary renunciation of office for any length of time shall not be considered as an interruption in the continuity of his service for the full term for which he was elected. True or false? True. Voluntary renunciation of office for any length of time shall not be considered as an interruption in the continuity of his service for the full term for which he was elected. This is applicable to senators and congressmen. What is the composition of the House of Representatives? Not more than 250 members, unless otherwise fixed by law. It consists of district representatives and party list representatives. What is the House of Representative allotment for district representatives? District representatives who shall be entitled to 80% of the seats to be elected from legislative districts. What is the House of Representative allotment for party list representatives? Party list representatives who shall constitute 20% of the total number of representatives elected through a party list system of registered national, regional, and sectoral parties or organizations. What is the rule in apportionment of legislative districts? It must be based on a uniform and progressive ratio. What is the rule on apportionment of cities? Each city with at least 250,000 inhabitants shall be entitled to at least one representative. What is the rule on apportionment of provinces? Each province, irrespective of number of inhabitants, shall be entitled to at least one representative. What is the rule on apportionment of a legislative district? Each legislative district shall comprise, as far as practicable, contiguous, compact, and adjacent territory. What is gerrymandering? Gerrymandering is the practice of creating legislative districts to favor a particular candidate or party, based on the case of Tobias versus Abalos. What are the qualifications for party list representatives? Should be President of the Philippines for a period of not less than 1 year immediately preceding the day of the election. At least 25 years of age on the day of the election. For youth sector nominee, you must be at least 25 years old but not more than 30 years old on the day of the election. Able to read and write. And last, a bona fide member of the party or organization he seeks to represent for at least 90 days before the day of the election. What are the grounds for refusal and or cancellation of registration of political parties? First, it's part of the religious sector. Second, advocates of violence or unlawful means of seeking its goal. Foreign party or organization. Receiving support from any foreign government, foreign political party, foundation, organization, whether directly or through any of its officers or members, directly through third parties for partisan election purposes. Sixth, fails to comply with the rules and regulations relating to elections. Seventh, declares untruthful statements in its petition. 8. Ceased to exist for at least 1 year or fails to participate in the last two preceding elections or fails to obtain at least 2% of the votes cast under the party list system in the two preceding elections for the constituency in which it has registered. Is the 2% threshold in the distribution of additional party list seats of the Party List System Act constitutional? The Supreme Court declared as unconstitutional the 2% threshold in the distribution of additional party list seats in the second clause of Section 11B of RA number 7941, the Party List System Act. The court held that the provision struck down as an unwarranted obstacle to the attainment of the broadest possible representation of party, sectoral, or group interests in the House of Representatives. Based on the case of Barangay Association for National Advancement and Transparency versus Comelec. What is the legal basis of the immunity from arrest of a senator or member of House of Representatives? Section 11, Article 6 of the 1987 Constitution. A senator or member of the House of Representatives shall, in all offenses punishable by not more than 6 years' imprisonment, be privileged from arrest while the Congress is in session. No member shall be questioned nor be held liable in any other place for any speech or debate in the Congress or in any committee thereof. What is the rationale of the immunity from arrest of a senator or member of the House of Representatives? To enable the lawmakers to perform legislative duty without fear of criminal prosecution. However, the provision does not protect them from the possible disciplinary actions that their colleagues might impose. Is a senator or member of the House of Representatives' immunity from arrest absolute, meaning he cannot be arrested during his term? No, his immunity from arrest is not absolute because this applies to offenses punishable by not more than 6 years of imprisonment. If the crime is punishable by more than 6 years, then the member can be arrested. Specifically, those punishable by prisión mayor. What is the legal basis of a senator or a member of a House of Representatives' freedom of speech and debate? Section 11, Article 6 of the 1987 Constitution. No member shall be questioned nor be held liable in any other place for any speech or debate in Congress or in any committee thereof. When does the freedom of speech and debate of a member of a House of Representatives apply? The privilege applies only while Congress is in session and not when it is in recess. What are the inhibitions imposed by the Constitution on legislators? Legislators shall not personally appear as counsel before any court of justice or before the electoral tribunals or quasi-judicial or other administrative bodies. Legislators cannot be interested financially, either directly or indirectly, in any contract, franchise, or special privilege granted by the government. Upon assumption of office, legislators must make a full disclosure of financial and business interests. They must notify the House concerned of a potential conflict of interest that may arise from the filing of a proposed legislation of which they are authors. Legislators may personally appear as counsel before any court of justice or before the electoral tribunals or quasi-judicial or other administrative bodies. True or false? False. Legislators shall not personally appear as counsel before any court of justice or before the electoral tribunals or quasi-judicial or other administrative agencies. Legislators may be interested financially either directly or indirectly in any contract, franchise, or special privilege granted by the government. True or false? False. Legislators cannot be interested financially either directly or indirectly in any contract, franchise, or special privilege granted by the government. What is the general rule on incompatible office among senators and members of Congress? The general rule is that a member cannot accept any other office, employment in government during his term unless he waives or forfeits his seat in Congress. Is a hearing required before the forfeiture of the seat in Congress or cessation of a member of Congress tenure based on an incompatible office? No, no hearing is required before the forfeiture of the seat in Congress or cessation of a member's Congress tenure based on an incompatible office because its forfeiture should be automatic. What is the exception to the general rule on incompatible office among senators and members of Congress? Exception. No forfeiture shall take place if the member of Congress holds the other government office in an ex officio capacity. What is the rule on forbidden office? A member of Congress cannot be appointed to any office which may have been created or the emoluments thereof increased during the term for which he was elected. What is the voting requirement to initiate an impeachment proceeding? One-third of all members of the House of Representatives. What is the voting requirement to convict an impeachable officer? Two-thirds of all members of the Senate. What is the voting requirement for the proposal to amend or revise the Constitution? Three-fourths of all members of both houses. What is the voting requirement to concur in treaties or international agreements? Two-thirds of all members of the Senate. What is the voting requirement to override the veto of the President in the passage of a bill? Two-thirds of all members of both houses, voting separately. What is the voting requirement to declare the existence of war? Two-thirds of all members of both houses voting separately. What is the voting requirement to concur in the executive's power to grant amnesty, reprieves, commutations, and pardons? Majority of all members on both houses. What is the voting requirement to submit to the electorate the question of calling a constitutional convention? Majority of all members of both houses. What is the voting requirement to declare that the President is unable to discharge the powers and duties of his office? Two-thirds of all members of both houses voting separately. What is the voting requirement to revoke or extend the President's suspension of the privilege of the writ of habeas corpus or proclamation of martial law? Majority of all members of both houses voting separately. What is the voting requirement to call a constitutional convention? Two-thirds of all members of both houses. What are the cases when the Constitution requires yeas and nays to be recorded? First, last and third readings of a bill. Second, upon one-fifth of the members' request. Third, repassing of a bill over presidential veto. What is the voting requirement to put the yeas and nays in the journal? One-fifth of each house. What is the voting requirement to elect a Senate President? Two-thirds of all members of the Senate. What is the voting requirement to elect the Speaker of the House of Representatives? Two-thirds of all members of the House of Representatives. What is the voting requirement to confirm a new Vice President nominated by the President? Majority of all members of both houses voting separately. What is the voting requirement to law granting tax exemption? Majority of all members of both houses. What is the requirement to constitute a quorum to do business? Majority of each house. Can the judiciary review the internal rules of Congress with regards to disciplining its members? No, the disciplinary action taken by Congress against a member is not subject to judicial review because each house is the sole judge on what disorderly conduct is based on the case of Osmeña versus Pendatun. What is the scope of the bicameral conference committee's powers? Adopt bills entirely or amend or revise or reconcile the House bill and the Senate bills. Propose entirely new provisions not found in either the House bill or the Senate bill. When can the president veto an item? A president can veto an item when it is an appropriation, revenue, and tariff. Can the president veto a condition imposed on an item of appropriation but not the amount of appropriation? No, the condition is an essential part of appropriation. To validly veto the condition, the president must also veto the amount of the appropriation. Based on the case of Gonzales versus Macaraig, what is the enrolled bill doctrine? The signing of a bill by the Speaker of the House and the President of the Senate, and its certification by the secretaries of both houses of Congress that such bill was passed, are conclusive of its due enactment, based on the case of Arroyo versus De Venecia. What is the rule on realignment of funds? The general rule is no law shall be passed authorizing any transfer of appropriations. Exception. This is an exclusive list. The following may by law be authorized to augment any item in the General Appropriations Law for their respective offices from savings in other items of their respective appropriations. First, the President. Second, Senate President. Third, Speaker of the House. Fourth, Chief Justice of the Supreme Court. And last, the heads of the constitutional commissions. What are the two types of electoral tribunals in the legislative? The Senate Electoral Tribunal, or SET, and the House Electoral Tribunal, or the HRET. What is the power of electoral tribunals? The electoral tribunals of the Houses of Congress shall be the sole judge of all contests relating to the election, returns, and qualifications of their members. May the decisions of the electoral tribunals be reviewed by the Supreme Court? Yes. The decision of the electoral tribunals may be reviewed by the Supreme Court only upon showing grave abuse of discretion in a petition for certiorari filed under Rule 65 of the Rules of Court. Do members of the HRET enjoy security of tenure? Yes, members of the HRET may not be terminated except for a just cause, such as the expiration of the member's congressional term of office, his death, permanent disability, resignation from the political party he represents in the tribunal, formal affiliation with another political party, or removal for other valid cause. A member may not be expelled by the House of Representatives for party disloyalty, short of proof that he has formally affiliated with another political group. Based on the case of Bandok versus Pineda. When does the jurisdiction of HRET or SET start? The COMELEC's jurisdiction over election contests relating to election, returns, and qualifications ends, and the HRET's own jurisdiction begins once a winning candidate is proclaimed, taken his oath, and assumed office as a member of the House of Representatives, based on the case of Agabao versus Comelec. What is the composition of the HRET or SET? 3 justices of the Supreme Court designated by the Chief Justice. The Senior Justice shall be its chairman, and 6 members of the Senate or House of Representatives. What constitutes a quorum in the HRET or SET? Rule 6, paragraph A of the 2015 HRET rules requires the presence of at least 1 justice and 4 members of the tribunal to constitute a quorum. This means that even when all the justices are present, at least 2 members of the House of Representatives need to be present to constitute a quorum. What is the power of congressional oversight? The power of congressional oversight embraces all activities undertaken by the Congress to enhance its understanding of and influence over the implementation of legislation it has enacted. Clearly, oversight concerns post-enactment measures undertaken by Congress. First, to monitor bureaucratic compliance with program objectives, to determine whether agencies are properly administered, to eliminate executive waste and dishonesty, to prevent executive usurpation of legislative authority, and to assess executive conformity with the congressional perception of public interest. Based on the case of Abacada Goro Party List versus Purisima. Differentiate inquiry in aid of legislation from question hour in terms of purpose. The purpose of inquiry in aid of legislation is to elicit information that may be used for legislation. The purpose for a question hour is to obtain information in pursuit of Congress's oversight functions. Differentiate inquiry in aid of legislation from question hour in terms of the nature of attendance. For inquiry in aid of legislation, attendance is compulsory. For question hour, attendance is discretionary. Differentiate the inquiry in aid of legislation from question hour in terms of the persons required to attend. For inquiry in aid of legislation, any person may attend. For question hour, only department heads may attend. Who are those exempted from attending an inquiry in aid of legislation and question hour? For inquiry in aid of legislation, the President, Supreme Court Justices, members of the AFP, if prevented by the President as the Commander-in-Chief. For question hour, department heads who fail to secure the consent of the President prior to appearing before either houses of Congress. Differentiate inquiry in aid of legislation from question hour in terms of one who conducts the session. For inquiry in aid of legislation, Senate or House committees. For question hour, the entire body. Differentiate inquiry in aid of legislation from question hour in terms of the subject matter. For inquiry in aid of legislation, any matter for the purpose of legislation. For question hour, only matters related to departments. Differentiate inquiry in aid of legislation from question hour in terms of the basis of the inquiry. For inquiry in aid of legislation, it is grounded on the necessity of information in the legislative process being coextensive with the power to legislate. For question hour, it is Congress merely seeking to be informed on how the department heads are implementing the statutes which it has issued. What may not be included as subjects of inquiry in both inquiry in aid of legislation and question hour. First, executive privilege, which must be invoked by the President himself or through the Executive Secretary by authority of the President. Second, privileged information, national defense, diplomatic, or military secrets. Third, those that may infringe the person's right to self-incrimination. What is the nature of the Congress's power to punish for contempt? The exercise by Congress or by any of its committees of its contempt power is based on the principle of self-preservation. Such power is sui generis as it attaches not to the discharge of legislative functions per se but to the sovereign character of the legislature as one of the three independent and coordinate branches of the government. How long can one be punished for contempt in the House of Representatives? Can only last until the final adjournment of the last session of such Congress. How long can one be punished for contempt in the Senate? Can last until the termination of the legislative inquiry, even during recess, under which the said power is invoked. The legislative inquiry of the Senate terminates in two instances. First, upon approval or disapproval of the committee report. Second, upon the expiration of such Congress. Who has the exclusive power to initiate impeachment proceedings? The House of Representatives shall have the exclusive power to initiate all cases of impeachment. What are non-legislative powers of Congress? Informing function and the power of impeachment. What is the informing function of Congress? The power of Congress when it investigates is either in aid of legislation or by way of oversight. What appears to have been forgotten is an equally important and fundamental power and duty of Congress, and that is its informing function by way of investigating for the purpose of enlightening the electorate, based on the case of Akbayan versus Aquino. What is the basis of the impeachment powers of Congress? The President, Vice President, the members of the Supreme Court, the members of the Constitutional Commissions, and the Ombudsman may be removed from office on impeachment for and conviction of culpable violation of the Constitution, treason, bribery, graft and corruption, other high crimes, or betrayal of public trust. All other public officers and employees may be removed from office as provided by law, but not by impeachment. Multiple impeachment proceedings may be initiated against the same official within a period of 1 year. True or false? False. No impeachment proceedings shall be initiated against the same official more than once within a period of 1 year. What are the grounds for impeachment? Bribery, graft and corruption, culpable violation of the Constitution, treason, betrayal of public trust, and other high crimes. When are impeachment proceedings deemed initiated? Impeachment proceedings are initiated upon filing of the complaint and/or resolution and its referral to the Committee on Justice in the House of Representatives. What are the other non-legislative powers of Congress? To act as Board of Canvasser in election of President, to declare the existence of war, to delegate emergency powers, call a special election for President and Vice President, to give concurrence to treaties and amnesties, to propose constitutional amendments and constituent power, to confirm certain appointments of officers of the AFP from the rank of colonel or naval captain and up, and ministers whose appointments are vested in him by the Constitution, chairman and members of constitutional commissions, regular members of the Judicial and Bar Council, and decide disability of the President because the majority of the Cabinet disputes his assertion that he is able to discharge his duties. May the list of these congressional powers, both legislative and non-legislative, be expanded by statutory legislation? No, the list is exclusive. It may not be expanded by statutory legislation. Based on the case of Sarmiento versus Mison.